Well, thank you very much, and it's great to see so many people here and more still pouring in. Clearly, this is a hot topic. I'd like to specially welcome our panellists and to congratulate the Monash Association of Debaters for their magnificent contribution to this evening. Many of you will be aware that this is a world champion debating team. They won the World Championship, I think it was last year or the year before, and reached the semi-finals this year. So we're in a very elite company when it comes to debating. I'd like to thank the staff at our Peninsula campus of Monash University and also the Frankston City Council for making this evening possible. And in particular, I'd like to thank the staff who work with me in my office, and Melinda and Julie, Zoe, Michael, and of course you, Duncan, for all your contribution. And I'd like to particularly mention one of our staff who's not here tonight, and that's Britta Morrison. Sadly, Britta was involved in a major car accident on the weekend and is in intensive care at the Alfred at the moment, and we pray for her recovery. The role of a university is to promote scholarship and research and to engage with the community in facilitating both academic discourse as well as debate on controversial issues in a free, open and respectful manner. We live in a multicultural, pluralist and hopefully tolerant society. Our society has seen reforms in laws governing prostitution, abortion, surrogacy, gay rights, and continues to debate euthanasia. People bring their cultural and religious backgrounds to these debates. Nevertheless, in a civil and democratic society, the boundaries between morality, religion and the law keep shifting, and we've seen this shift in relation to legalisation of abortion in certain circumstances, legitimisation of surrogacy, gay couples are having and adopting babies, various sections of the clergy have appointed women and gay priests, and the rights of cohabiting gay couples to property in the event of separation or death has been protected. So why not gay marriage? And that's what tonight's topic is all about. Now, I want to warn the speakers that unlike my usual self, I'm going to stick to time. I'm known for not doing that. So there'll be a 2-minute warning bell and a sign will flick up to warn you that you have 2 minutes to go, and then there'll be a final double bell, at which time you will be terminated. The first speaker is for the affirmative, and it gives me great pleasure to introduce Sue Peninsula, who is the member for the Victorian Legislative Council. She's the Greens member for the Victorian Legislative Council, representing the Southern Metropolitan Region. She was first elected to the Victorian Parliament in 2006, and she has been an active member, particularly in the area for environment and planning, ever since. I'm proud to say that she studied arts and applied science and has a master's degree in environmental science from Monash University. I give you Sue Peninsula for the affirmative.
Thank you very much for your introduction. I'd like to say that I'm delighted to be here to open debate for the affirmative team with my colleagues, Professor Paula Gerber and Ms Madeline Schultz, who will be speaking after me. Marriage equality is an issue of great importance, and it is an issue that is dear to my heart. It's one I've been campaigning for many years. I will be opening our team's argument with a short description of the legal status of marriage in Australia and internationally, and why the issue, and an explanation of why the issue is so prominent in public debate today. And I'll broadly outline the case for marriage equality from a legal and a human rights perspective. And I'd like to start by reading out the countries around the world that have so far legislated for marriage equality. So marriage equality is currently recognised in the Netherlands, in Belgium, Canada, Spain, South Africa, Norway, Sweden, Portugal, Iceland, Argentina, several states of the United States and Mexico City. Further, legislation for marriage equality is under consideration in Denmark, the United Kingdom, Ireland, Brazil, Mexico, Colombia, Finland, Nepal, Slovenia, France and Paraguay. And I'm sure everyone is aware that recently the President of the United States came out in support, Barack Obama came out in support of marriage equality, as did the New Zealand Prime Minister John Key. And the current President of France also campaigned on a platform for marriage equality, or was part of the platform for that campaign. So Australia is lagging behind in terms of marriage equality. And I say that marriage equality must and will occur in Australia, and that the Commonwealth Marriage Act will be amended to provide for marriage equality. Now, up until 1961, marriage was a state issue, and the Commonwealth Marriage Act of 1961 drew together that under the Commonwealth legislation, the Marriage Act 1961. And as we all know, in 2004, the Marriage Act was amended to specify that marriage is between a man and a woman. Previously, the Act had not been so specific, only to say that marriage was between two people voluntarily entered into for life. And I agree with Justice Alastair Nicholson, who's the Chief Justice of the Children's Court, who said that that was the most unfortunate piece of legislation to pass the Australian Parliament. I agree with him, because that law, that change to the Marriage Act, which I would remind us all is a civil institution governed by secular laws of general application. It should apply to all citizens equally. And the changes in 2004 made the Act discriminatory. It made the Act to discriminate against certain sections of the community based only on their sexuality. And that's not the case with any other secular law of general application, in particular since the changes in 2008 under Commonwealth legislation, which removed all other forms of discrimination against against gay and lesbian people. So I agree with Justice Nicholson that a terrible mistake was made in the Australian Parliament in 2004, and that must be rectified. At its core, the Marriage Act is a dry and secular act. It is basically a contract between two people, governed by an Act of Parliament, and as I say, it should apply to all Australians equally, with no exceptions or exclusions. Many Australians who do get married opt to be married by a civil celebrant. That is, 2/3 of people who get married do so in a civil ceremony, at the park, at the beach, in their backyard, or some of them just in the registry office with 2 independent witnesses, which is the minimum requirement under the Act. There's no requirement for any ceremony, let alone a religious ceremony. So one of the arguments that we do hear about comes from a religious perspective, that marriage is a religious institution, but in fact it is a civil institution. Some people do choose to enter into marriage, the civil institution of marriage, with a religious ceremony, but it doesn't make it a religious institution. So what we're talking about here is a secular law. It should apply equally to all Australian citizens. It should not exclude any Australian citizens based on any attribute which those Australian citizens might hold. So I say it's unconscionable and a blight on our statute books that the Marriage Act is discriminatory and excludes a section of our community. I also say that it is hurtful to same-sex couples who wish to marry that they are not able to do so, that they have less rights than their fellow Australians. And such blatant discrimination under the law also sends a message to those in the community who may be inclined to discriminate against lesbian, gay, bisexual, transsexual, or intersex people, that it is okay to do so because the law of the land does so. This is intolerable in a modern democratic and secular society. It leads to greater rates of depression and suicide within this part of our community, and to bullying, harassment and violence against them. On the contrary, Marriage equality would send a message that all love is equal, that same-sex relationships are as valid and precious as heterosexual relationships, and it would also serve to remove the licence that some people take to continue to discriminate, or worse, to bully, harass or be violent towards others based on their sexuality. It would send a positive message to young people who may be struggling with their sexuality. There's also the issue of the changes that were made under the changes that were made in 2004 to the Marriage Act, which has confused the issue for transsexual and intersex people. Which the confusion, if the Marriage Act is amended to say simply that marriage is an institution between two people entered into voluntarily for life, would remove that confusion. Some people would say, well, why marriage? Why don't we just have civil unions and relationship registers for same-sex couples? We introduced a relationships register in 2008 in Victoria, and I said in the debate in the Parliament on the introduction of that law that that is still a lesser institution than the community and same-sex people who wish to be married view marriage to be, and it is deliberately intended to be so. So what we need is full equality under the law. The relationships registers would be okay, in my view, if we had full marriage equality, so that any two persons, regardless of their sex, their sexuality or their gender identity, could marry. And we also had relationship registers for those people who want to register their relationship, could also use them. So I'm in favour of relationship registers if they're available to all people at the same time as we have marriage equality. Because I understand a lot of people don't actually want to be married, but the point here is that we are excluding a section of the community and saying to them, you can't get married. Now, I think those people who find difficulty with accepting that need to put themselves in the boots, in the shoes of the same-sex people who want to get married, their friends and their family, and how they feel having that discrimination visited upon them. Another argument we often hear against marriage equality is that somehow it will undermine other people's marriages. I really can't see how it would have an effect on anyone else's marriage, but I also say that making marriage an equal institution open to all people, regardless of their sex, their sexuality or their gender, will enhance marriage. It will make marriage a better institution. And those people who want to get married will find more fulfilment from marriage by being aware that it is available to all people. I know I was watching Q&A the other night. People might have seen David Pocock. I'd never heard of him before. I don't follow rugby. But he did say that he and his partner, his girlfriend, had said they won't get married until their same-sex friends are able to. So they're not going. They believe in marriage. They want to get married, but they won't until their same-sex friends are able to. So the time for marriage equality is well and truly here, and let's do it.
Thank you very much, Sue. Thank you. Well, it gives me pleasure to introduce the first speaker for the negative, and that's Gemma Buckley. Now, Gemma is an art student at Monash University and president of the Monash Association of Debaters. She's a grand finalist in the Australasian Debating Championship and a semi-finalist in the World University Debating Championships. I give you Gemma Buckley.
It's unfortunately all too convenient and all too common for people who support gay marriage to claim that this is a debate between the left and the right, to claim that it's a debate between atheists and between religious individuals, or to claim that it's a debate between progressivism and conservatism. That dichotomy is inaccurate, and that's what I'm going to demonstrate in my speech tonight, because there is a significant voice that actually doesn't get heard in this debate, and that's not the voice of the gay community full stop, and it's not the voice of the religious community. It's the voice of gay individuals who actually actually don't support gay marriage. It's the voice of the left and progressive individuals who don't think gay marriage is actually a good thing and who want to stay well away from marriage. And that's the thing that I'm going to bring you in this debate, because the reality is that opposition to gay marriage doesn't just come from the church. It doesn't just come from the traditional aspects of society. It doesn't just come from the right. It also comes from a small but important minority within the gay community, and those are the individuals I'm going to represent. But before I get to that, I'm going to respond to 3 things that Sue said in her speech. And the first of those was when she pointed to the trend of other countries to move towards gay marriage as some sort of justification for why Australia should do it. I'm going to throw something back at Sue and suggest that just because a whole lot of other countries in the world haven't done anything to fight climate change isn't a reason for us to stop doing what we're doing and just jump on board with that apathy. So the reality is, just because other countries in the world choose to undertake a particular policy isn't, and nor should it be, a reason for Australia to do that unless we can actually justify why that policy in and of itself is a positive thing. So we don't think that trend is significant enough in this debate. The second thing from Sue's speech that I actually want to engage in is the conversation about whether or not marriage is in fact a civil institution and is in fact a secular one. Because I would question that outright, and I would say just because the government has usurped marriage and has made it a civil institution does not mean that marriage begun a civil or a government institution, and does not mean it should remain one. Just to clarify what I mean there, I don't mean that gay and lesbian individuals shouldn't be able to access a government-recognised marriage. In fact, our team supports civil unions. But even more broadly than that, I think every single atheist in the room should only be able to access a civil union and shouldn't be able to access a marriage. And that has nothing to do about whether or not that person is gay or straight or who they want to marry. It has to do with the fact that marriage as a concept is rooted in religious fundamentals and is a part of religious doctrine. And we're going to hear more on that from my other speakers. So we don't think that marriage is ever going to be open to all people. We think marriage as a concept is exclusionary, and we think that's acceptable so long as there is something else which takes up the position which marriage doesn't hold for those individuals. We think civil unions does that fine, and I'll talk a little bit more about what civil unions actually do for gay individuals later on. The third thing from Sue's speech that I want to engage with is the messaging effect of legislation. And this is the part, to be honest, that I disagree with most. I think it is outrageous to suggest that an individual who would be so bigoted and so small-minded as to harass a homosexual individual took their cues from a piece of legislation. The reality is that people who are small-minded, that people who think it's acceptable to discriminate against individuals or bash them, as Sue suggested, are actually small-minded bigots and not people who fervently follow government legislation and take that as an acceptable reason to undertake those types of behaviour. I think that is just taking away fundamental responsibility from individuals who choose to do the wrong thing in our society. We should call out those individuals and prevent that behaviour, not just blame legislation and its messaging effect. So before I give you some arguments in this debate, I want to clarify what the status quo is with regards to civil unions. Because the reality is that as of 2007-2008, the majority of places in Australia do allow, in a practical sense, gay and lesbian couples to access the same types of practical rights with regards to superannuation, with regards to taxation, with regards to a whole lot of other things as every other couple. So in a practical sense, those things are equal. And to the extent that they're not, and to the extent that there are still places in Australia that do not recognise those things, we would happily extend those things to those particular states on this side. We support that. So what does this legislation actually aim to do for the purposes of actually having this debate? The proposed changes are to remove the words husband and wife, to remove references to gender on those certificates, and also a sweeping amendment that allows other consequential changes to be made by regulation. It's that the negative team in this debate doesn't support. So in this debate, I'm going to make 3 arguments to you. I'm firstly going to tell you that gay marriage isn't necessary in a practical sense for gay and lesbian couples. I'm secondly going to tell you that it will not lead to the equality that gay and lesbian couples seek with the particular communities who do not currently recognise them as equal. We don't think on this side of the House that it will actually be effective at changing the beliefs of those communities. And I'm thirdly going to tell you why gay and lesbian couples shouldn't want to be associated with marriage in any form and why they should run the hell away from it in the opposite direction. So, firstly, is marriage in and of itself actually necessary. Because as I said already, the reality of this debate and the reality of the way our society functions right now is that in a practical sense, civil unions can guarantee the same things as a marriage would. So this debate is actually about the name you give to that relationship. The question isn't whether or not we guarantee the same protections to gay and lesbian couples. We already do that, and we should do that in places where we don't. So the question is, does the name make a significant change? We say on this side that it actually doesn't make a significant change. The reality is that the broad populace supports gay and lesbian couples, believes that their relationships are just as legitimate as any other relationship, believes that their lifestyles are just as acceptable as any other. Those individuals are not going to be convinced or are not going to change their mind or are not going to really interact with this legislation in any meaningful sense. So the people for whom we actually want to make a difference are the people who don't currently believe those things, are the people who don't think that gay and lesbian relationships are equal, are the people who don't believe those individuals should be able to access the equal rights as other people do. Those individuals are not going to change their opinion because the government passes a piece of legislation that they do not support. And that's the reality in this debate. Whilst we concede that there are individuals who don't believe in those things, that there are individuals who still do have a backwards opinion about gay and lesbian couples, we don't concede for a second that a change in government legislation actually changes the opinions of those individuals. We think, if anything, it makes those individuals more fervently opposed to gay and lesbian couples because those individuals are now accessing the same marriage that they perceive to be sacrosanct to them. To be clear, it's not something that I feel, and it's certainly not something that I endorse, but the reality of this debate and the reality of this discussion is that those individuals for whom minds need to be changed, who we actually need to target, are not the ones who are going to interact with legislation and change their minds. So the question you actually have to ask yourself is, will changing the name from civil union to marriage do anything practically different? We say no. The second question is, will it do anything metaphorically different? Will it change the rhetoric of individuals who do not support gay and lesbians? We say no. That's unfortunate, but that's the reality. So ultimately, we don't think it is going to make a huge difference. The second thing I want to say, though, aside from just like that obvious stuff, is that even if it would make a difference, we think gay and lesbian couples, or I think gay and lesbian couples, should stay the hell away from marriage. The reality of marriage in today's society is, to the extent that it means something, to the extent that the institution of marriage has some kind of value, we think that means something very different to what it used to. We think marriage nowadays means corporatization, it means spending, it means counselling, it means divorce. It doesn't mean all the things that individuals would like to claim it does. So to the extent that marriage might have a rhetorical power, we don't think that rhetorical power is in any way positive in the modern sense. Even taken at its best, marriage is exclusionary. It will always be exclusionary. Even if we open it up to include gay and lesbian couples, it will never be truly reflective of the diverse number of relationships that individuals choose to engage in our society. It will always try and promote monogamy over unmonogamous relationships. It will probably never recognise polygamy. It will probably never recognise a whole host of other types of relationships which are completely legitimate. The reality is, marriage as an institution is exclusionary to individuals, and even if we continue to open the barriers, we don't think it will ever be fully non-exclusionary. But beyond that, it's important to remember that no matter how much the state has tried to usurp the institution of marriage, finally, it does have a relationship to religion. Religion that fervently opposes, that comes from a place that doesn't support their lifestyle, that comes from a set of individuals who fight against the ability of gay and lesbians to marry, who fight against those policies. Because the reality of this debate is that marriage isn't a positive thing to be associated with. It has an incredibly problematic history. It has an incredibly problematic status quo where divorce rates are over 50%. Moreover, it's based completely on social expectation. People in modern day often don't even want to get married and are kind of forced into it because it's the expectation and because it's the norm, not because they pursue marriage in a meaningful sense because they think it's going to actually improve their lives. The important part of all of this, aside from me just ragging on marriage for a few minutes, is to suggest that if it is true that marriage has any kind of meaning and the word has any kind of rhetorical power, that power is gone and it's no longer positive, and wherever possible, I think gay and lesbian communities should try and stay away from it. But the reality of this debate is that the functional difference naming this marriage will make is pretty meaningless. It's not going to change the opinion of incredibly bigoted individuals, and it won't give gay and lesbian couples anything beneficial aside from linking them to an institution which is outdated, which is exclusionary, and which doesn't support their lifestyles. I think they should stay away from it. We're happy to not support gay marriage in this debate.
Thank you very much, Gemma. Now it gives me great pleasure to introduce the second speaker for the affirmative, and it's Associate Professor Paula Gerber. Paula Gerber is an Associate Professor in the Law School at Monash University and Deputy Director of the Caston Centre for Human Rights. She has a background in private legal practice and has worked in the UK as well as in the United States. She did her PhD at Monash University around the aspects of the UN Convention of Human Rights of the Rights of the Child, and in 2009 was appointed to the board of the Victorian Human Rights and Equal Opportunities Commission. I give you Paula Gerber.
Thank you very much. As you heard, I am an academic specialising in human rights, and in particular my area of expertise is on the rights of the child. So that's what I'm going to be talking about tonight. And I became interested in this area of marriage equality when I started reading opinions by people like Tonti Filippini, saying that we should oppose same-sex marriage because it's against the best interests of the rights of the child. So, being an academic specialising in the rights of the child, I decided to do some research. So I started with the Marriage Act, of course, and looked at it from beginning to end and couldn't find the word child or children mentioned anywhere in there because, of course, children or procreation is not an essential element of marriage. If it was, we wouldn't allow women over the age of 45 to marry, we wouldn't allow infertile couples to marry. So to say that same-sex couples should not be able to marry because they can't naturally produce children is really a bit of a furphy, because it is true that a lot of children are born and raised by married couples, but it's also true that a lot of same-sex couples are having children. In fact, the most recent data from the census 2011 came out, and it showed that there are, at a minimum, 6,120 children being raised by same-sex couples. And I say at a minimum because there are still people out there who will not want to disclose on a census that they are gay because they fear recrimination and discrimination. So at a minimum, we have 6,120 children in Australia being raised by same-sex couples. And that's possible because we as a society several years ago decided that the sexual orientation of a person had no relevance or no bearing on their capacity to parent. They were as good a parent or as bad a parent regardless of whether they were gay or straight. And this conclusion was reached because there have been now years of studies that demonstrate that having a gay parent does not negatively impact on the well-being of a child. I say there are lots of studies out there. There is one exception. A very recent study, just the last couple of months, came out from an academic at the University of Texas, Mark Regenis, and he found exactly the opposite. Having a gay parent was really bad on the prospects of the child, which raised a few eyebrows because it was contrary to all these other longitudinal studies. The only thing I'll say about that study is that it is currently the subject of investigation, or that academic is a subject of investigation by both the publisher of the journal in which the research appeared and the University of Texas for professional misconduct and unethical research. Basically, it now appears that the research design and methodology employed by that academic was far from scientific, and that the design and methodology could only ever produce the outcome that it did. So, what we have in Australia is a decision by society that same-sex couples can have children, and they can do that by fostering children, by adopting children, by accessing fertility services. So to say that same-sex couples should not have children is really the horse has bolted, the ship has sailed, that fight has been fought. So people like Margaret Somerville, an Australian-Canadian academic who recently published an article, The Case Against Same-Sex Marriage, based entirely on the fact that children should have a mother and a father, it's irrelevant in Australia because we've already made that decision that same-sex couples can have children. So the relevance of marriage is what it does to children of same-sex couples when you tell them your family is different, your family is less worthy, your parents are not allowed to marry. And I say that prohibiting same-sex couples from marrying is a violation of the rights of the child. And when we're talking about the rights of the child, we turn to the Convention on the Rights of the Child, a UN treaty with 193 countries have ratified. 193 countries have said this is our benchmark, this is what we aspire to when it comes to how we're going to treat our children. And that treaty has 3 key principles on which it's founded, and I want to briefly talk about those in the context of this same-sex marriage debate. The first principle is in Article 3, and it says, in all decisions concerning children, the best interests of the child shall be a paramount consideration. What is it doing to the interests of a child when you tell him or her, your parents are not allowed to marry, you are not allowed to be raised within a married household? Well, a study published in the prestigious Paediatrics Journal in the United States said this: marriage is a legal status that promotes healthy families by conferring a powerful set of rights, benefits and protections that cannot be obtained by other means. Civil marriage can help foster financial and legal security, psychosocial stability and an augmented sense of societal acceptance and support. Legal recognition of a spouse can increase the ability of adult couples to provide and care for one another and fosters a nurturing and secure environment for their children. Children who are raised by married parents benefit from the legal status granted to their parents. It is not adequate to say civil unions, as Gemma suggested. In fact, we've had that experiment before. It was called the separate but equal policy in the United States. The gay community does not want to be separate but equal. They want to just be equal. So I suggest to you that to prohibit a child's parents from marrying on the basis of the fact that they are a same-sex couple is against the best interests of the child. Another key principle in the Convention on the Rights of the Child is Article 2 on non-discrimination. And what that provision says is that it is a breach of a child's rights to discriminate against that child on the basis of an attribute of their parent, be that race, religion, disability, age or sexual orientation. When you treat a child differently because of an attribute of their parents, you are breaching that child's rights. And I think this is very well illustrated by a quote I'd like to read to you from a Victorian same-sex family that was part of a submission to a Law Reform Commission inquiry. And they said this: the lack of legal recognition of and support for our family translates in practice to some people regarding our families as deficient and problematic. Laws that aim to discourage our families from existing or that don't recognise our families as families make it harder for or more awkward for some people to include us or interact with us and our children, and can make some people feel that they can or should treat us with a lack of respect or as though we are invisible or deficient. Gemma's argument was legislation's not going to change attitudes. I disagree entirely. If we adopted that rationale, why abolish apartheid if it's not going to change racist attitudes? It may not happen overnight, but it will happen. The third and final principle of the Convention on the Rights of the Child that I want to refer you to is in Article 12, and that is the right of children to be heard and to participate in decisions that affect them. I'm pretty confident that no one from the Australian Christian lobby or other opponents of same-sex marriage have ever actually gone and spoken to children being raised in same-sex families. Because if they had, they could not in all good conscience maintain their position. Because it is very clear that the children being raised in same-sex families want their parents to be recognised, their relations to be recognised, and to be part of this wonderful institution of marriage. I accept that Gemma doesn't think it's a wonderful institution, but I don't think she speaks for the majority. And so an article was recently published in the ABC online webpage, The Drum, by a number of people who had been raised by same-sex parents, and I'd like to read you an extract of what they said. They said, "We were raised in supportive and loving environments by parents who were willing to defy expectation and discrimination in order to create families. We knew we were loved, cherished and wanted. We believe, having lived this experience ourselves, that children need love, stability and security, not two parents of an opposite gender. We have learned that family is more than biology. It is a community you create. Family is shared memories, facing hardships together, building a life together. Our lives were not perfect because no one's lives are perfect. But the hardships and challenges we faced are not due to having same-sex parents. They are due to bigoted viewpoints. They are due to living in a society that does not respect or honour our experience. We do not deserve to be treated as second-class citizens. We know what it is like to be raised by same-sex parents, and we know what it is like to face prejudice and discrimination as a result of that. Allowing same-sex couples to marry is upholding the principles in the Convention of the Rights of the Child. I can do no better than express it I can't express it any better than the way Nelson Mandela did when he said there can be no keener revelation of a society's soul than the way in which it treats its children. It's time we treated all children equally and we gave them the respect and dignity that they deserve by allowing them to be raised by married parents. Thank you.
Thank you, Paula. The next speaker for the negative is Professor Nicholas Tonti-Filippini. Those who followed ethical debate in this town and this country will be familiar with the contribution that Nick has made to that debate. He is currently the Associate Dean, Teaching, Learning and Research and Head of Bioethics at the John Paul II Institute for Marriage and Family. He continues as a consultant in bioethics. He holds honours and master's degrees from Monash University and a PhD from the University of Melbourne, for which I forgive him. Over to you, Nick.
Well, thank you for having me back, even though I did go to Melbourne after being at Monash. It's a great privilege to be back on a Monash-sponsored event. And I'm very grateful to the Monash Debating Society for inviting me here for this. It's not the first time I've been part of Monash debating circles, so it's good to be back. We all have friends or family who are gay or lesbians, and these are people we know and love, and they're part of our families. The Rudd government's removal of laws that discriminated against them was most significant in ending inequality in the law in some 89 areas. Now, though, we face something different. The redefinition of marriage to exclude the words a man and a woman from what marriage means, and consequential legislation in relation to that, to in effect remove the effect of gender from much of the law that applies in relation to marriage, and that will have implications also for status of children legislation and for all the certificates and so on that go with marriage. We'll be talking person one and person two and parent one and parent two rather than bridegroom and bride and father and mother. What is at stake in this redefinition is the biological reality of the two-in-one flesh union between a man and a woman and its importance to children. In response to the previous speaker, that understanding of marriage, that it's between a man and a woman and that it's needed in relation to children is simply implicit in the legislation, and it's clearly expressed in the International Covenant on Civil and Political Rights in Article 23, which talks about the right to marry and form a family and links marriage in that way to family formation, and uses a definition that's very much like the definition in the Travaux Paratois, like the definition that's in our Marriage Act now, that it's between a man and a woman to the exclusion of all others for life. And it adds in that documentation, there's commentary added in relation to being orientated towards children. Biological marriage establishes rights and duties in relation to children because the couple is bound to each other and to the child at every level: genetic, gestational, nurturing, social, physical and spiritual. Biological marriage is not just a relationship of mutual benefit to the spouses. Rather, the love is by design fruitful and outreaching, potentially involving mutual and unilateral obligations of motherhood and fatherhood that have a biological origin. That's why the law provides for the celebration of biological marriage and gender difference and recognises the uniquely generative power of the union between man and woman. It's much more than romance. The couple's relationship is open to being extended to include children who come into existence as an equal third party to the union, an embodiment of their love for each other, and thus as a permanent sign of their love for each other. As a consequence, marriage confers security and identity on the children who result from the biological union and the unconditional obligations of being mother and father at all levels: genetically, gestationally, socially, physically and spiritually. The possibility of children is what defines what marriage means. The biological parents of a child are in fact irreplaceable. A step-parent never has exactly the same status because their relationship is always overshadowed. Much as I admire people who adopt children and foster children, they don't actually fulfil the same role as the natural parents do. The reality of the existence of a natural biological parent is different, and those who have been adopted will tell you that. The search for identity of and access to natural parents by many donor offspring is tantamount to the importance of biological parenthood. The major difference between biological and step parenting is that biological parenthood is much more than a choice. This proposed removal of the union of a man and a woman and the consequent exclusion of gender from the documentation goes hand in hand with state laws in relation to the status of children, in which, though the word mother has been retained, and in that sense the law still is discriminatory, and retained for the woman who gives birth, and the words father and husband have been removed in all those states that have legislated to allow same-sex parenting and surrogacy. Husbands and fathers then are now simply parents in the law in those states, or substitute parents. There's no such thing in the Victorian Reproductive Technology Act as a father. A child in a surrogacy arrangement also has no legally recognised mother under the agreements once they are in force, with her role being taken by parent 1 or parent 2, or a substitute parent or parents. Professor Tom Frame of Charles Sturt University, in evidence to the Senate Select Committee in May this year, said, given that children raised by a married same-sex couple will not be nurtured by both their parents, indeed the child will have at least 3 parents, the committee needs to consider this potential consequence of amending the Marriage Act, that a same-sex couple will be married, and marriage is understood to be the pairing of 2 people to the exclusion of all others. The capacity of a donor, for instance, to be involved in the nurture of a child will inevitably be affected. And we saw recently in a court in New South Wales where the child's natural father was removed from the birth certificate in favour of a same-sex substitute parent. It's ironic, when we are aware of how much children have suffered from absent fathers, that the proposed law is no longer to honour the role of biological parents, especially fathers, but also mothers. This process of redefinition would, in fact, be a cause of great injustice to children, denying them their right to know, to have access to, and to be nurtured by their biological mother and father, rights recognised by international law. And I say this advisedly, having taken Indigenous advice. We are in danger of creating another stolen generation in Australia. In a same-sex union in which there are children, the child is always a stepchild of at least one of them. In reviewing the literature, I found a large number of studies on types of parenting, including some fourth-level studies. The review leads me to conclude that there is almost no material available on parenting by two men, but there is some material about parenting by two women of young children. If they are in a stable relationship, then the research tends to indicate that there is not an immediate disadvantage for a young child being brought up by two mothers, rather than by a mother and a father. However, tragically, the weight of evidence also indicates that, especially at adolescent level, stepchildren are at greater risk cognitively, emotionally, and in relation to social problems. When the structural factors are taken into account, a child living with stable biological parents is likely to do better than a stepchild within a secure parental relationship to a parent and a step-parent. The absence of a biological parent matters. Since a child in a same-sex situation will always be a stepchild of one of the parties at least, as adolescents they suffer the same advantages of lacking a direct relationship to at least one natural parent. When one of the biological parents is not resident and not taking a nurturing and authoritative role in the child's life, the child suffers, especially as an adolescent, when the unusual origin is likely to be known and meaningful and a part of the young person's identity. Further, the difficulties often extend into adulthood. Because the evidence indicates that the problem of being a stepchild is not resolved by living with married parents rather than de facto parents, there is also little evidence to support the idea that gay marriage would benefit children because the child will always be a stepchild in those circumstances. Marriage is not just about romance and the love between two people. If the law changes to make legal marriage just about romance, as the proposed definition would do, then that will create a moral problem for both ministers of religion and couples who believe in the biological marriage status quo. Conscientious ministers of religion, as has happened in the Anglican Church in the UK, would have to address the issue of whether we should adopt the European situation in which religious marriage and legal marriage have separate ceremonies and dual registration for each, and withdraw from the legal role. For couples in biological marriage, there will be the issue of whether they should conscientiously avoid having their marriages legally registered because the law would no longer recognise their reality. Unfortunately, gay marriage is biologically an impossibility, and changing the law would rob us of the institution of marriage and make marriage no longer recognised for what it is, as a love that goes beyond romance at all levels to establish the unilateral bonds of the project of being mother and father together and being bound to each other by that shared biological relationship to the child, and thus protecting the child's identity, security, lineage and family connectedness. Thank you.
Now, the next speaker for the affirmative is Madeline Schultz. And Madeline Schultz is a science law student at Monash University and well known in the debating society. She has an extensive debating career at university with great success on a national and international level. Earlier this year, she reached the semi-finals of the World University Debating Competition, and in July she won the Australasian Debating Championships held in Wellington. It gives me great pleasure to give you Madeline Schultz.
Well, ladies and gentlemen, about an hour ago, Nicholas and I met for the first time ever. And putting aside his current marital status, which I have no awareness of, we could go down to City Hall and apply to get married tomorrow. And no one there would test my fertility or his fertility. They wouldn't test our competence as parents. They wouldn't test how likely we were to choose to have children or how good we would be at raising them. The state doesn't have a role to determine whether or not I'm able to marry someone on the basis of what I might choose to do with that marriage in the future, on the basis of the quality of my relationship with that individual. That is a personal and private choice, and one that shouldn't ever be handed over to someone who hasn't lived in that relationship, experienced what I am feeling or what I am not feeling. We don't think that's any more acceptable for same-sex couples than it is for couples who happen to be heterosexual. We don't think that's acceptable in this debate. So, In this debate, I'm going to talk about three themes, three questions at the end of this debate. I'm going to talk about religion and whether or not we're somehow changing the definition of marriage in a way that rips it away from the churches that supposedly created it. I'm going to talk to you about discrimination, and I'm going to talk to you about children. I want to start with religion. We wondered how long it would take from Nicholas. The idea that we're redefining the definition of marriage. We redefined the definition of marriage when we required women to consent to it. We redefined the definition of marriage when we allowed interracial marriage. We redefined the definition of marriage when we allowed divorce. So let's not get so hung up on definitions in this debate, particularly not on the basis of a religious text that endorses incest. Because if you want to accept some definitions, don't run away from the rest of them. So here's the thing. The state recognises divorce. Australia does. The Catholic Church doesn't. And there's nothing wrong with that dichotomy. There is a difference between a civil marriage, between the relationship between two individuals that the state recognises, and whether that recognition is forced on the Catholic Church. This debate doesn't change the ability of the Catholic Church to discriminate in terms of what relationships they value. We hope that they'll be good people and change that themselves. But we recognise we can't force them to change any more than we could force them to recognise divorce. And that's the way it should be. Not just because doing it in any other way would be homophobic, but because doing it in any other way would be religious discrimination. Why did they get to choose? Why that religion? Why not the large number of religions that actually support same-sex marriage and believe that it's entirely compatible with their religion and with their history? Why does the Catholic Church get to claim it? Let's not pretend that marriage doesn't predate the Catholic Church. They didn't create it, they don't own it. Society does. And they should have no more right to define my relationship or your relationships than anyone else does in society. We question how happy they'd be if, for instance, we handed over control of marriage to the Buddhists and let them define what was necessary for a marriage to be recognised. Let's move on to talking about discrimination. Now, at First Negative, we had a really interesting approach to this from Gemma, where she tried to dodge this by ceding all possible control of marriage to religion. So we applaud the attempt at equal opportunity discrimination here. But we don't think that extending your discrimination to cover atheists or members of non-Judeo-Christian religions justifies your discrimination against same-sex partners in this debate. Why? Because the denial of the name of marriage, the denial of that title, is actually important. Because what that does is endorse a narrative of difference, endorse a narrative of discrimination, and endorse a narrative of abnormality that is forced on certain members of society. When you tell those individuals that they don't have the same right to be recognised, the same right for their relationships to be celebrated by the entirety of society, you do hurt those individuals. You do discriminate against them. And we wonder how willing they would be to applaud the extension of all rights without the word marriage attached to it if we decided to apply that to Catholics, or if we decided to apply that to any particular religion, or interracial couples, or any other group that wanted to get married in society. It's not good enough to adopt separate but equal. Individuals want equality that is not just equality in technicalities alone. It is about that recognition. But then they tried to deny the benefit, and they said, really, the real reason it's not discrimination is we wouldn't improve anything by really recognising these relationships, because it's not going to stop the bigoted people. It's not going to stop them expressing their views. Well, what gave you the right to decide that the same-sex community should be defined by that? What gave you the right to decide what they should prioritise or what they should care more about? Why should they care more about whether or not this will convince bigots than whether or not they want to be recognised as equal? Why should they prioritise those things? We never heard a convincing reason why the First Negative speaker had a better right to define what they should choose to campaign for than those individuals who are living that life and living that discrimination. And it's fine if some individuals don't want to get married, whether or not they're straight or gay. It doesn't make a scrap of difference. That doesn't mean that we should ignore the large number of individuals who care about that, and care about that being available to them, and care about that state recognition of the equality of their relationship. But also, we'd point to the example of South Africa, where when they legalised same-sex marriage, the recognition of same-sex rights was incredibly low. The recognition even of those people's right to life was incredibly low. And the leaps and bounds of improvements in that country, massively outpacing other countries with similar levels of opinions towards same-sex attracted individuals, demonstrates how much a government that chooses to lead the population can achieve in terms of getting equality for those individuals and getting them recognised by the society around them in a way that allows them to genuinely enjoy all of the same rights as others in society. It's finally turned to talking about children. And Paula told you about the incredible cost to children of denying their families equal recognition under the law. And Nicholas's response to this was to say that there is something unique about being male and female and joining in that relationship. As I told you in my introduction, the state doesn't test fertility and it doesn't test parenting capability. We wouldn't allow people over the age of 50 to get married if it was about that. We wouldn't allow people who had previously been bad parents to get married if it was about that. But we don't do either of those things because we recognise that marriage is primarily about the individual. It's primarily about the nature of their relationship with someone and their desire to see that recognised and recognised by the society around them. But then he said it's about the biological link to the children. You're ripping these children away from their true families. A couple of things. Firstly, we're not kidnapping them from their beds. We're not taking these children away from loving families who want them. These children are being born to the families that want them, or adopted by families who care about them where their birth families didn't. Even if there were lesser outcomes for the children who were adopted, we question what the alternative is for those children. But Paula told you about the studies that showed that individuals who are raising children in same-sex committed relationships have the same outcomes for those children. In fact, in many studies, they show better outcomes for the stability of those children. And so then they fell back on the idea that they would be very depressed in their teenage years, that these children would feel unaccepted by a society. A couple of things there. We question how much of that is because society doesn't accept their families, rather than because their families are doing a bad job. We also question how much of that, considering that the studies you were using to demonstrate that were in fact about step-parents, not same-sex couples, how much of that was about the fact that those were children who'd just gone through their parents getting divorced. But ignoring all of that, we don't measure your capacity to be a parent except where you fail drastically at it. If we did, we wouldn't issue 2/3 of the marriage licences we do. People don't become naturally able to be good parents just because they're particularly biologically compatible, even if we bought that as an argument. So the idea that this is something that we should care about and this is something that should determine whether or not we allow these individuals to get married is wrong. What we should care about is the discrimination that those individuals suffer when the state refuses to recognise them. What we should care about is the effect on their families, on their children when those children feel that their families aren't recognised. What we should care about is whether we think it's acceptable for religious institutions to define our relationships for us, particularly when those are religious institutions that only represent a small portion of society, when the large majority of society supports same-sex marriage. I want to conclude by saying this. Secularism matters, because secularism is what prevents me from imposing my definition of marriage on the negative team, and it should also be the thing that prevents them doing the same thing to me. And we question how willing they would be to accept these kind of separate but equal arguments if we applied them to their religions or to their personal characteristics. It's not enough to pretend that we can give people all the same technical rights and just deny them the label, because the only reason to deny them the label, then, is pure discrimination. If you're willing to give them everything else, the ability to adopt, the ability to cohabit, the ability to choose to raise families together, the only reason to deny them the name of marriage is pure discrimination. We don't accept that in this debate, and we're very proud to stand against it.
The third and final speaker for the negative is Dan Flynn. Dan Flynn is the Victorian State Director of the Australian Christian Lobby. He's a qualified lawyer and practiced at the bar from 1989 to 2006 before commencing as solicitor with the Victorian Government. From 2008 until joining the ACL this year, Dan managed a team of government prosecutors conducting environmental cases in Victorian courts. I give you Dan Flynn.
Thanks very much, Professor. It's a privilege to be at Monash having been a Melbourne student myself. On Monday, the Immigration Minister, Chris Bowen, indicated his support for traditional marriage, saying that he had surveyed his electorate of McMahon and that there was overwhelming community support for traditional marriage. He said that many people told him that the importance they placed in traditional marriage, and so accordingly he would vote that there be no change to the definition of marriage. The Australian Marriage Equality convener, Alex Greenwich, accused Mr Bowen and other MPs of copping out and hiding behind their electorates. The people of McMahon have made a good point, ladies and gentlemen, and that is this. Traditional marriage does have a great place in people's lives, in people's communities, and it has had a great place right throughout the generations. We're talking about millennia. Anthropologists will find couplings of mother, father, immature child consistently throughout societies. They'll be a part of the community, but they'll be distinct. And that family, that coupling, predates the state and predates the state's regulation of the marriage relationship. The state has, I suppose, put its stamp of approval on marriage because it's a design that's been manifested, it's been maintained and flourished. So marriage did not come into play by reason of statute, and it's not going to be easily changed by statute because it's such a real part of the world we live. Marriage, as people have known it for centuries, is the union of a man and a woman. That's not new, and it's not taking away anybody's rights. The power of marriage comes from the tradition that emphasises permanence. It's an important social function of marriage to encourage couples to stay together and to properly socialise their children and provide security. Marriage endeavours to achieve this by its emphasis on monogamy and commitment for life. Anthropologists have found there's no form of marriage within societies strong enough to stick that didn't have the element to it till death us do part. Now, as was said in a recent BBC debate, gay activists and others have redefined the view of marriage to be understood not so much as till death us do part, but for as long as both parties find satisfaction in it. That doesn't sound very permanent, it doesn't sound very secure, particularly for the children who look to parents for security. My concern is that legalising the same-sex marriage is likely to further reduce commitment to permanence in that institution. Ladies and gentlemen, let's face it, marriage is already under stress. Two-thirds of marriages survive, and that's good for kids, but the concern is that by bringing into marriage same-sex marriage, there'll be less of a commitment to permanence. The statistics reflect that gay marriage among men is less likely to be permanent. American researchers, Werter and Madison, who found in their survey the gay couple, and they're themselves gay, they found this. Of the 156 couples that they surveyed, after 5 years, only 7 had remained faithful. And that's not surprising. Dennis Altman, who is a gay advocate, said at the Sydney Writers' Festival, the gay male culture is not a monogamous culture. So the concern is that if formalised, if celebrated, and this is a point well made recently by Andrew Bolt, that if this is incorporated into our traditions, that will so influence all who participate in marriage about the decisions they make about their own commitment and the tradition that binds them to their partners and, most importantly, to their children. We're being reassured that the redefinition of marriage will have no impact on the churches and faith-based institutions. However, a redefinition would have a significant impact. We're being asked to accept what's being described by Robert George, a professor from Princeton University, as a grand bargain. The grand bargain goes like this. We will accept the redefinition of marriage. You will respect our right to act on our conscience without penalty, discrimination or civil disabilities of any type. That bargain will never be accepted, except perhaps in the short term, for tactical purposes, so that marriage can be redefined. But the guarantees of religious liberty that are being offered in the current legislation won't last. They'll be eroded and they'll be eventually lost. 7 Labor senators, in their comments on the Green bill, in the report, the Senate report, said this: "The assurance that ministers will not be compelled to solemnise same-sex marriages is hollow and tactical. Anti-discrimination laws will be the weapons against those who disagree with the equality of same-sex marriage." And we know, look, in Denmark, I think it was June, Lutheran churches, 10 years following the legalisation of same-sex marriage, are now forced to conduct marriage seminars. Similar things, marriage ceremonies. We see in Massachusetts, where marriage was legalised same-sex in 2004, 2 families tried to take their children out of the reading of a fantasy book called The King and the King, promoting same-sex marriage. The parents sued for the right to take the children out of school. That was knocked back by all of the courts. What does that tell us? That tells us that when same-sex marriage becomes law, your right to determine what your children are taught about what is right and wrong is out the window. Could I say this? There is no overwhelming support for same-sex marriage. This is a very important point. The latest Gallup poll indicates that support for same-sex marriage dropped from 62% in February to 50% in May. Now, the Ambrose organisation did a survey, September 2011. They found that 49% of people supported same-sex marriage, but when further questions were asked, they said, 73% said, look, I think a child is best with their mother and father, and 59% said we should be slow to march into this until we're aware of the social effects on children. So, how can Adam and Steve hurt your marriage? If same-sex marriage becomes law, people who believe that children are better off with their biological parents may be considered to be bigots, and that's a major concern. This debate is not about private behaviour, it's about the redefinition of marriage. And it's to be noted that certainly the Australian Christian Lobby supported all of the 84 amendments to eliminate discrimination against the gay community. Ladies and gentlemen, we can perhaps finish on this note. Shane Newman and Mike Simon, both MPs, in their comments in the House of Representatives reports, they are Labor members, they said this: they do not believe there's anything like sufficient community census to justify a change in such a fundamental and societal institute as marriage. I submit to you, ladies and gentlemen, there is no such consensus. Great pause ought to be given to this, considering at best the jury's out on whether this would be in the best interests of children. Thank you for your time.